Time for thinking real estate. Are you here?
She's trying to
I
wake
didn't
up.
know if I was supposed to say something.
Oh,
I
well,
thought-
you always do. So.
Oh, I'm sorry. So I love to throw you off every now and then.
Lord Dwyer Schlecke, Bill Schlecke,
I was gonna say, usually say who's in the room.
Jackie Austin.
Yeah.
Yeah.
Oh. Well, there you have it.
She was just waiting for that cue.
Well, I was trying to think of who I was going to have on next week because you just threw that on the table that you won't be here.
You only knew that for the last month and a half.
Well, I wasn't. No, I didn't know the exact day.
Oh, you didn't?
No.
Yeah, it's next month. I'll be gone.
You'll be gone for your birthday.
I will be gone. for my
Bill's
birthday.
going to be, how old? 67?
Very good. It's nice when your own wife knows how.
Well,
old you
but
are.
for
When you get up there,
for 9
when you get to
months
those
be-
numbers, it gets really tough.
when you went 9 months before your
I
birthday,
hear
you
you.
start saying you're the age you're going to be.
Oh,
then.
come on, don't give me that.
So then you're going to be 68.
No, I'll be 67. No sense in
Don't rush
advancing it. Yeah, exactly right.
I can't believe October's gone so fast, but Halloween's almost here.
Halfway home.
Okay. All right. So I thought yesterday someone said to me they were going to call. Last night I went to the NAACP banquet. That was a good banquet. Anyhow, and someone there had said they were going to call and ask a question about, and I don't know the whole question, but I'll
So you're just
Kind
gonna
of
give me
play off
part of it.
Paraphrase it?
Yeah,
I'll-
just give me part of it, right? So
Right.
that I can
Well, you
try to
can handle
answer
it.
something. Right.
You claim you can talk about anything whether you know about it or not, right?
Yeah, sure.
Okay. Anyhow, apparently the seller had the buyer had a home inspection done, but the seller was still sued for something that was found during the home inspection, or found as a result. I don't know. They sued the seller. So let's talk
Okay,
about home
so this is a
inspections.
question that you don't know
No, the
what
question.
the question is?
Correct, right.
Okay.
Well, I got interrupted, I think, during it. But so the moral of the story is we could talk about home inspections and where does the liability lie. If there's something, the buyer has a home inspection done, they move in, and they find something wrong.
Yeah, leaky basement or
Sure.
leaky roof or something like
Where
that.
does the liability fall?
Oh boy, how much time you got?
20
We got
minutes.
about 20.
Not enough time. Give me another question. Yeah, I mean, you can start.
That's a good question,
Yeah,
actually.
well, sure it is. It's a great question, but it's really difficult to answer in the sense that it takes a little bit of time. Now, let's start with the basic. The basic in Michigan is caveat emptor, buyer beware. Michigan is a state that still
No Latin here on this show.
de gustibus
Does
non
non
disputandum
disputandum
est.
Like I said, no.
There is no disputing taste. Come on, lawyers talk.
No Latin or pig Latin.
Lawyers talk. Do you know why lawyers use Latin? And you know why lawyers use words like whereas, here and above, set forth, herein.
Because they got paid by the word.
That's exactly right. In the old days, only priests and lawyers were able to write.
You don't
And so they
charge
were-
by the word here, do you?
They were
On
scriveners.
your radio show?
God, no, I talk a lot more.
So they were scriveners, and so they got paid by the word. That's why you see all that. And the trend these days is to write in plain language. But I got a purchase agreement from a lawyer the other day, and it still had all of these herebys, herein, above set forth.
Well, our
all that sort of
ordinances
stuff.
at the city are that way.
They
It drives
shouldn't
me
be.
crazy.
Yeah, they shouldn't be. There's no reason to use the word herein or therein.
And I
or-
can't get them to start
things like that.
changing it.
Whereas,
Yeah, it's just stupid, you know. And in the recitals, you still put recitals, but you don't need whereas the parties da 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 da. Whereas they desire to resolve the dispute
Well, that's
between
what
them. that sort of thing.
resolutions all say.
Yeah, but that's stupid. You don't need to do that.
All right, let's get back to the question at hand.
Okay, so caveat emptor or buyer beware. That's the starting point in Michigan, and it's been affirmed and reaffirmed time after time by the Michigan courts. There are very few exceptions to caveat emptor. One exception is if, and then you're talking about solely in the context of a house, Laura?
Yes.
yes. Yeah.
Don't call, well, aren't you going to say something like, don't call me Laura again?
No.
Yeah. Don't call me Shirley, right?
Yeah.
So, anyway. Anyway, you start with caveat emptor, but one of the exceptions to buyer beware. It- I have a conversation that's going on in my ear.
We're
so it's
listening
all-
to
No, but
this-
it's tough to concentrate with that conversation going on the side. So at any rate, every sale in Michigan, even if it doesn't say as is we start off with the proposition that a sale is as is in Michigan. Buyer beware. The exceptions. One would be if the defect is a hazardous condition and is not disclosed by the seller. Hazardous condition. I always use the example of the movie with Kathy Bates, and the name escapes me, where her husband falls through the hidden dry well that's out in the field. Another hazardous condition could be, I had a case over in the Pontiac area on a lake over there where the house was subsiding into the lake itself. There's another issue with that one. So if it's a dangerous condition, the seller has a duty to disclose. If the property is contaminated, if the seller is not, if the seller knows it's contaminated, should have known it's contaminated, or is on notice that it may be contaminated, we have a statute that says the seller must disclose that to a purchaser. So
What about
hazard-
an underground oil tank, which would be pretty common in a residential on the country house?
Well, now.
Or
now-
not uncommon, let's put it that
All
way.
right, let's assume that that's not a hazardous condition, because it's not filled with fuel, it's been, under
Abandoned.
the old days, abandonment meant it was left, it was drained, it was left in place and filled with inert material, water or sand. So let's assume it's not a hazardous condition. Let's assume that it's not contaminated, although you could make an argument that the seller, knowing that the tank exists, should know that it may be that there may be contamination. But let's assume neither of those. Now you get to the next stage, which is, did the seller commit active fraud? In other words, if you ask the question as a buyer of the seller, is there an underground storage tank on the property? And that's part of your seller's disclosure statement. If the seller knew that there was, and the seller lied on the seller's disclosure statement, saying that there was no underground storage tank, knowing that there was, and now in Michigan as well, if a competent, qualified home inspector would not have found it upon an inspection, irrespective of whether the purchaser had the inspection or not, then the seller is going to be liable. In other words, the seller knows of the tank, seller made an active misrepresentation, fraudulent misrepresentation, and the tank couldn't have been discovered or wouldn't have been discovered by an inspector, then the seller is liable. That's active misrepresentation. There's also something called innocent misrepresentation in Michigan, which is a recognized cause of action, where if the seller doesn't know that there's an underground storage tank, but there is one, but the seller represents, instead of saying unknown, says no, innocent misrepresentation.
Well, if you
Then
lived
the
in the
seller
house
is liable.
and you didn't know one was there, what would make you say unknown? Why wouldn't you say no?
Because you don't know.
Okay.
I wouldn't say no unless I absolutely knew that there was a tank and I had it removed, or my prior seller said there was a tank and it was removed, in which case I'd say there used to be a tank but it's been removed. But if I'm a seller of property and I don't know of a particular defect, but I make an affirmative representation to a buyer that no, that defect does not exist, that's called innocent misrepresentation, and Michigan recognizes that cause of action. The seller's liable. So you have.
So if I buy a house, previous seller, on their seller's disclosure says no underground storage tank. We buy it, we now sell it, we put no underground storage tank, relying on the previous seller's representation. Where does that put us?
Innocent misrepresentation. You made an active representation. This is why on a seller's disclosure statement, you've got to be very careful of what you say.
Well,
You-
despite the fact that the previous seller told us there wasn't one?
What does that matter?
Well,
The seller your
We
seller may have
relied
been
on-
lying. Your seller may not have known it.
well, could you go back on that?
Good luck with that. Statute of limitations would be, in most cases, 6 years. Let's see, damage is probably a 6-year statute, so general rule is no. Okay? So that's so you have hazardous condition, you've got contamination, you've got active fraud. you have innocent misrepresentation, and then the last category is where it's called active concealment. In other words, the case I was giving you where the house was starting to subside or fall into the lake, interestingly enough, what the sellers had done is they built a false wall in the basement so that it hid the fact that the foundation was starting to subside into the lake. They were liable for active concealment. In other words, they didn't make an active misrepresentation, but they did something to conceal the defect from a prospective purchaser. And those are the
Could it be
categories
a
of liability.
combination of?
Could be all of those. I mean,
Okay.
but it's easier. It's
So
easy-
if there's a wet basement, the home inspector lets the buyer know there's a wet basement, doesn't know the cause of the dampness, is the seller liable?
Probably not, because Michigan has gone a step farther. And in fact, in a case in which I was involved in, this is 20 years ago, up in Livingston County, which went to the Court of Appeals. The Court of Appeals said that in Michigan, the common practice is for a buyer of a home to have a home inspection. And in that case, they didn't have a home inspection, but the court held the buyer to the following standard, namely, if the buyer had done what was custom and practice and actually hired an inspector, and had the inspector discovered the particular defect, in your case a wet basement, easy to discover, then the seller is not liable because the buyer was not relying upon any representation or silent fraud on the part of the seller. They had an opportunity to discover the defect. They failed to avail themselves of that opportunity by failing to hire an inspector. Michigan law says seller is not liable. And in your case, once the buyer sees the wet basement or the inspector finds it, now they know of the defect. Now they make inquiry of the seller. If the seller lies about the condition of the basement, in other words, the seller knows that there's a more serious problem and minimizes it to the purchaser, now the seller is committing active fraud. In other words, the buyer availed himself of the inspector.
That could be tough to
Inspector
prove.
found it. It is. All fraud is very difficult to prove, and the standard is, we have several standards of proof or burdens of proof. The easiest one is called preponderance of the evidence. In a
Right.
contract claim, preponderance of the evidence, more than 50%. To prove fraud, it has to be, quote, clear and convincing evidence, which is a higher standard. Not as high as reasonable, beyond a reasonable doubt, but it's a higher standard of proof, clear and convincing evidence.
Okay, you got a leaking roof.
Yeah.
What if you don't know it's leaking? Because you could be leaking into your attic and you don't know it.
That's right where I was going.
All right.
Okay.
You've got a leaking roof.
Yeah?
You get an inspection. The inspector, of course, he doesn't find it.
No, well, why doesn't the inspector find
I
it?
don't know.
Doesn't go into the attic crawl space.
Here's what
I don't know.
here- Well, but that becomes the issue in court, because now the buyer has to present an expert inspector who will come in and have to testify that a qualified, competent inspector could not have found this particular defect, either because it was behind a wall that you can't do destructive testing, or because it was concealed by the seller. The seller's lawyer is going to hire another expert inspector who's going to come in and say that had this inspector hired by the purchaser been a competent, qualified inspector, that inspector would have found the defect. So what you did is you hired a schmuck to do the inspection.
Or you hired a relative, or which is not
No, or you ask a
uncommon.
relative. That's
Yeah,
very
you
common.
could-
But
Brother Joe to do it. Or,
No.
well, you have two issues
I
on
know.
that.
Do they do
And
that?
I always say to my buyers, hire a professional inspector and hire someone you're willing to sue. If you're not willing to sue your brother, then don't use them.
Right, that's exactly right. First of all, the brother probably doesn't have the qualifications, and even if the brother does have the qualifications, if the brother screws up, you're gonna sue the brother, and then even if you sue the brother's probably doesn't have any assets.
But you
anyway.
could get the greatest pro alive and they could miss.
Well,
But
sure,
they have
but
usually
Especially
have-
like a leak in a roof. Okay?
But the inspector,
Sure.
a good inspector's going to have liability or insurance.
yeah, but
So they pay?
Wait a second, guys. Wait a second.
Okay.
Simply missing a defect doesn't mean that the inspector was negligent. You have
That's
to
what
show
I'm
that the
saying.
inspector was negligent. It might not have been discoverable for a period of months or years. It might not have
Right.
been discoverable until a heavy rain. So you can't automatically pin it on an inspector for missing a defect. All the inspector has to be is qualified and competent and meet the standard of care within the community in which the inspector
And
does his business.
Who knows when that leak
Okay?
started?
Who knows when it started, who knows when it occurs. There may not be any evidence at the time the inspector goes through because it's winter time and there is no leaking.
So this would be a real buyer beware.
Buyer beware, that's why it's so crucial for a buyer to hire a competent inspector to go through the property.
But he can still miss something.
Of course he or she can,
Yeah.
but anybody can, you know.
And that doesn't make him incompetent.
Does not make him incompetent, does not make him unqualified, does not say that he or she committed negligence in the inspection.
So the buyer is probably out of luck.
Well, no.
But if-
But you gotta remember, we have a seller disclosure law in Michigan with respect to residential properties. That's designed to protect the buyer. We have inspectors to protect buyers. I mean, think about what it was before Sellers Disclosure Act and before we had inspectors. There, the buyer was really hung out to dry in terms of trying to figure out what the condition of the property was. And I've been in practice 42 years. I was in practice during the era when we didn't have inspections. Inspections didn't start in earnest until the 1980s and 90s. You look at me rather quizzically, my dear.
So that was all buyer beware.
It was all buyer beware. It's still buyer beware, but we have mechanisms in place now through seller's disclosure statement and through inspections to be able to
What about
ameliorate the effect of.
What about an
caveat
inspection
emptor.
done by the seller at the time of listing the
Seller
house?
never should have an inspection done because the less the seller knows about the condition of the property, the less the seller represents that there is no defect on a seller's disclosure statement. Your example of an underground storage tank is absolutely perfect. Seller doesn't know of the existence rather than saying no. To the extent that the seller knows something, fine, put it in the seller's disclosure statement. But if the seller does not know, put unknown. And this ties in with our conversation 2 weeks ago about oil and gas rates. If I'm a seller now, I'm going to put, I don't know if I own those oil and gas rights because I can't get title insurance on it anymore.
Did Ron or anybody call you back?
Yeah, I've talked to Bob Newman, I've talked briefly with Ron, and that conversation is still going on. But what I want to do, we ought to continue this conversation. We're not going to have time today, but there are things you need to do as a buyer in terms of the inspection contract. But jump back to the seller. Your question about should the seller have an inspection done, a pre-sale inspection, the answer is absolutely, unequivocally no. And any lawyer or any realtor who recommends to the seller, hey, look, let's accelerate the process here, let's have you do a home inspection that we can give to the buyer, that lawyer and that realtor are absolutely nuts. Don't follow that advice as a seller.
Wouldn't that be honest?
No, I can be honest without having my own inspection done. In other words, why would I go looking for problems on my property?
Because you
That
want
now
it.
the law says I have to disclose.
Because you are just a wonderful human being and you want to make sure.
This
Well,
has
let's-
nothing, I'm still a wonderful human being, but I'm not gonna go out looking for problems, and I'm not gonna bury my
So
head in
if
the
I-
sand.
so if I find-
But I'm not gonna go out and hire somebody to find those problems, so now I end up having to disclose them.
What about-
That onus is on the
What
buyer.
about an inspection? Let's say we had an inspection done, got an offer on a house, buyer does an inspection, buyer backs out for, not because of the inspection, despite the fact there were a couple of items found on the inspection, but for another reason. One of the items might be radon. Is that something that has to be disclosed?
Well, wait a second, as a seller, I don't even wanna know what the buyer's inspector comes up with. All I care about is whether they're going through with the deal. I don't wanna see the inspection report from the buyer. What are you
I'm
talking
thinking
about?
of a specific property where they asked for repairs. The repairs were already in process. One of the repairs was a radon issue,
All right.
but they back out for some other reason other than the repairs.
Okay, so now the seller
So
knows
knows-
that there's an issue, so now the seller's gotta disclose. That's one reason why I usually tell my sellers, I don't care what the environmental report says, I don't care what the inspection report says of a buyer, you're either in or you're out, and if you're in, great, if you're out,
And you
We'll
don't
move
think
on.
it's a liability if a buyer backs out from a transaction due to the home inspection? You don't think as a seller I might want to know, or that I have a duty to find out what those
Well, that's up to you.
repair requirements.
Michigan imposes no duty on a seller to go searching for defects.
And then I don't have to disclose to the next buyer that I had a buyer that backed up because of the home inspection?
Well, but the buyer simply says, I'm dissatisfied with the condition of the property. But in your circuit, see, I do more commercial stuff where people just say I'm in or I'm out. You're dealing with homes where they always come back and they say, hey, we found a problem with the roof. We want the seller to fix the roof. Things like that. So now the seller knows of it, seller can't ignore it, can't bury his or her head in the sand. We can continue this conversation.
Well,
We always do.
Okay.
okay, but not next week.
Not next week,
Not
I'll be
next
good.
week.
You know, and after that, we'll be talking pheasants, I'm told. All right, I'm guessing.
We're talking peasants?
Pheasants. So I have a new listing on Trisha. It is a really cute
Where's
house.
Tricia?
Trisha, is there, yeah, Trisha office, Spring Arbor Road,
Oh.
out by, what's that golf course?
Arbor Hills?
No.
Hickory Hills?
Hickory Hills. Where you go through that little subdivision?
Yeah.
Yeah. So you can walk to the golf course from this house.
Wow.
It's a bi-level, 3 bedrooms, 2 full baths, almost 2,200 square feet of finished area, and it is $119,900. Move in, new carpet, freshly painted, all set and ready. There's a fireplace in the family room, big open rooms, lots of light, deck overlooking the back, fenced yard. And then we just decided, as we're standing here, we're going to do a short open house at 5515 Kibbe Road. And that is a really cute 3-bedroom, 1.5 bath, hardwood floors, farmhouse with a 3+ car garage, listed for $129,900, and we'll do that open house from 12 to 1 on Sunday, October 19th.
This coming Sunday.
Yep.
Give us that address again.
5515 Kibbe Road. And then I think Jackie's heading out to Meckley's. Something going on there. Who wouldn't want to go to Meckley's?
How much is that?
$129,900.
Thank you.
Western Schools.
Your phone?
780-3800.